The following material and content is covered under fair use. This is for training and educational purposes only, for teaching and commenting in a classroom setting. Again, this is for training and educational purposes only. This does not constitute legal advice, tax advice, or financial advice. If you need any applicable advice, please seek competent counsel. Do your own due diligence, regardless of who presents the information. All rights, title, and interest reserved without prejudice. Hey everyone, it's B with 2B Fruitful Training Group. All praises to the Most High. And today we're going over the applicability of UK laws in North America. To start, some basis in the Torah and the Tanakh. We have Proverbs 12 and 22. Lying lips are an abomination to the Most High, but they that deal truly are his delight. Exodus 20 and 16. Thou shalt not bear false witness against thy neighbor. Psalms chapter 119, verse 159 through 160. Consider how I love thy precepts. Quicken me, O Most High, according to thy loving kindness. Thy word is true from the beginning, and every one of thy righteous judgments endureth forever. Psalm 7, 10 through 13. My defense is of the Most High, which saveth the upright in heart. The Most High judgeth the righteous, and the Most High is angry with the wicked every day. If he turn not, he will whet his sword. He hath bent his bow, and made it ready. He hath also prepared for him the instruments of death. He ordaineth his arrows against the persecutors. So, out of Wikipedia, Charlatan's Web, we have secret trusts in English law. In English law, secret trusts are a class of trust defined as an arrangement between a testator and a trustee, made to come into force after death, that aims to benefit a person without having been written in a formal will. The property is given to the trustee in the will, and he would then be expected to pass it on to the real beneficiary. For these to be valid, the person seeking to enforce the trust must prove that the testator intended to form a trust, that this intention was communicated to the trustee, and that the trustee accepted his office. There are two types of secret trust: fully secret and half secret. A fully secret trust is one with no mention in the will whatsoever. In the case of a half-secret trust, the face of the will names the trustee as trustee, but does not give the trust's terms, including the beneficiary. The most important difference lies in the communication of the trust. The terms of a half-secret trust must be communicated to the trustee before the execution of the will, whereas in the case of a fully secret trust, the terms may be communicated after the execution of the will, as long as this is before the testator's death. Secret trusts do not comply with the formality requirements, such as witnessing, laid down in the Wills Act 1837. Despite this, courts have chosen to uphold them as valid. Although various justifications have been given for this, they are generally categorized as either based on preventing fraud, or as regarding secret trust as outside the operation of the Wills Act, deors. The first is considered the traditional approach. If the courts do not recognize secret trusts, the trustee given the property in the will would be able to keep it for himself, committing fraud. The fraud theory utilizes the equitable maxim that equity will not allow a statute to be used as a cloak for fraud. This follows another maxim of equity. Equity regards as done what ought have been done. So here we have the Treaty of Paris, 1763, and we're taking a look at Article 4. Now, context, what happened that led to this treaty was immediately prior. There was the 7-Year War, the French and Indian War. So the colonies of the French were fighting against the colonies of the British for 7 years. And the result was the Treaty of Paris. And reading out of Article 4. His Most Christian Majesty, the King of France, renounces all pretensions which he has heretofore formed or might have formed to Nova Scotia or Acadia in all its parts, and guarantees the whole of it, and with all its dependencies, to the King of Great Britain. Moreover, His Most Christian Majesty cedes and guarantees to His Britannic Majesty, in full right, Canada, with all its dependencies, as well as the island of Cape Breton, and all the other islands and coasts in the Gulf and River of St. Lawrence, and in general, everything that depends on the said countries, lands, islands, and coasts, with the sovereignty, property, possession, and all rights acquired by treaty or otherwise, which the Most Christian King and the Crown of France have had till now over the said countries, lands, islands, places, coasts, and their inhabitants, so that the Most Christian King cedes and makes over the whole to the said King and to the Crown of Great Britain, and that in the most ample manner and form, without restriction, and without any liberty to depart from the said cession and guarantee under any pretense, or to disturb Great Britain in the possessions above mentioned. His Britannic Majesty, on his side, agrees to grant the liberty of the Catholic religion to the inhabitants of Canada. He will, in consequence, give the most precise and most effectual orders that his new Roman Catholic subjects may profess the worship of their religion according to the rites of the Romish Church, as far as the laws of Great Britain permit. His Britannic Majesty further agrees that the French inhabitants or others who had been subjects of the Most Christian King in Canada may retire with all safety and freedom wherever they shall think proper, and may sell their estates, provided it be to the subjects of His Britannic Majesty, and bring away their effects as well as their persons without being restrained in their emigration, under any pretense whatsoever, except that of debts and of criminal prosecutions. The term limited for this emigration shall be fixed to the space of 18 months, to be computed from the day of the exchange of the ratification of the present treaty. So, the French ceded and lost the war, and they ceded and gave over in without any restriction to the King of Great Britain. So this is what started that. Now, what happened later, the Royal Proclamation of 1763 by King George, whereas we have taken into our royal consideration the extensive and valuable acquisitions in America, secured to our crown by the late definitive treaty of peace, concluded at Paris the 10th day of February last, and being desirous that all our loving subjects, as well of our kingdom as of our colonies in America, may avail themselves with all convenient speed of the great benefits and advantages which must accrue therefrom to their commerce, manufactures, and navigation, we have thought fit, with the advice of our Privy Council, to issue this our Royal Proclamation, hereby to publish and declare to all our loving subjects that we have, with the advice of our said Privy Council, granted our letters patent under our Great Seal of Great Britain, to erect within the countries and islands ceded and confirmed to us by the said treaty, 4 distinct and separate governments, styled and called by the names of Quebec, East Florida, West Florida, and Grenada, and limited and bounded as follows, viz. First, the government of Quebec, bounded on the Labrador coast by the river St. John, and from thence by a line drawn from the head of that river through the lake St. John to the south end of the lake Nipissing, from whence the said line, crossing the river St. Lawrence and the lake Champlain in 45 degrees of north latitude, passes along the highlands which divide the rivers that empty themselves into the said river St. Lawrence, from those which fall into the sea, and also along the north coast of the Bay de Chilou. I don't speak French. I'm not even, you see it. And the coast of the Gulf of the St. Lawrence to Cape Rosiers, from thence crossing the mouth of the river St. Lawrence by the west end of the island of Anticosti, terminates at the aforesaid river St. John. And farther, in the same proclamation, and whereas it is just and reasonable and essential to our interest and the security of our colonies, that the several nations or tribes of Indians with whom we are connected and who live under our protection should not be molested or disturbed in the possession of such parts of our dominions and territories as, not having been ceded to or purchased by us, are reserved to them, or any of them, as their hunting grounds. We do therefore, with the advice of our Privy Council, declare it to be our royal will and pleasure, that no governor or commander-in-chief in any of our colonies of Quebec, East Florida, or West Florida do presume, upon any pretense whatever, to grant warrants of survey, or pass any patents for lands beyond the bounds of their respective governments, as described in their commissions, as also that no governor or commander-in-chief in any of our colonies or plantations in America do presume, for the present, and until our further pleasure be known, to grant warrants of survey, or pass patents for any lands beyond the heads or sources of any of the rivers which fall into the Atlantic Ocean, from the west and northwest, or upon any lands whatever, which not having been ceded to or purchased by us, as aforesaid, are reserved to the said Indians, or any of them. And we do further declare it to be our royal will and pleasure, for the present, as aforesaid, to reserve under our sovereignty, protection, and dominion, for the use of the said Indians, all the lands and territories not included within the limits of our said 3 new governments, or within the limits of the territory granted to the Hudson's Bay Company, as also all the lands and territories lying to the westward of the sources of the rivers which fall into the sea from the west and the northwest, as aforesaid. So now we've covered how, according to the Treaty of Paris 1763, that the lands that were predominantly occupied by France were ceded and then given and guaranteed over to the British Crown. So that's what happened in 1763. And later in 1763, you have the Royal Proclamation by King George that stated that there was a reserve of all of the unsettled or unclaimed lands in North America held in trust for the remaining Indian tribes, the applicable Indian tribes. So with those two different events, now we have the Treaty of Paris 1783. And what this treaty did was it acknowledged via Article 1, it states here, His Britannic Majesty acknowledges the said United States, viz. New Hampshire, Massachusetts Bay, Rhode Island and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia to be free and independent states, that he treats with them as such, and for himself and his heirs and successors relinquishes all claims to the government, propriety, and territorial rights of the same and every part thereof. So now the 13 colonies have been acknowledged as independent and free states, e-states. So now we see what's being happened with these different colonies. The colonies are going from colonial governments to recognition as free states. So we've looked at the unsettled and unclaimed lands reserved by the Britannic Crown, reserved for the Indians there too. On the other side, the lands ceded and granted by treaty to the United States. So out of this, we have the Select Congress Resolution 76. This was a hearing before the Select Committee on Indian Affairs in Washington, D.C. And it states here, committee will come to order. This morning, the Select Committee will consider Select Congress Resolution 76, a resolution to acknowledge the contribution of the Iroquois Confederacy of Nations to the development of the United States Constitution, and to reaffirm the continuing government-to-government relationship between the Indian tribes and the United States, as established in the Constitution. This year has seen the beginning of numerous activities in celebration of the bicentennial of the United States Constitution. A number of Indian leaders believed that it was also an appropriate time to re-examine the history of the Constitution, particularly in terms of acknowledging the contributions of the Iroquois Confederacy of Nations in its formulation and to clarify the status of Indian tribes in relation to the United States. Over the years, the federal-Indian relationship has become a quagmire of confusion and misunderstanding, subjected to the whims of each administration. Our government's role has been marked by paternalism, conflicts of interest, and mismanagement on the part of the bureaucracy charged with the administering the lands and other assets of Indian tribes and individual Indians. Educational and legal scholars, in conjunction with Indian tribes and Indian leaders, have been researching the historical origins of the United States Constitution and the interpretation of key provisions of the Constitution that speak to the way in which Indian tribes and the United States relate to one another. There now appears to be a strong consensus emerging among Indian tribes that the United States has strayed from the original intent of the framers of the Constitution and their vision of the relationship between the U.S. and the tribes. This morning's impressive agenda of witnesses will address these issues and hopefully enlighten us from their perspectives as to what must be undertaken by the Congress if we are to preserve the original intent of the framers of the Constitution and keep faith with this government's historical commitment to the Indians. As some of you are aware, the Select Committee on Indian Affairs has recently established a special committee on investigations to examine the problems associated with the administration of Indian affairs and Indian programs. This special committee will begin operating in the very near future, and it is my belief that Select Congress Resolution 76 will be enhanced by the work to be undertaken by this special committee on investigations. The text of Select Congress Resolution 76 follows. Concurrent Resolution. To acknowledge the contribution of the Iroquois Confederacy of Nations to the development of the United States Constitution and to reaffirm the continuing government-to-government relationship between Indian tribes and the United States established in the Constitution. Whereas the original framers of the Constitution, including most notably George Washington and Benjamin Franklin, are known to have greatly admired the concepts, principles, and governmental practices of the 6 nations of the Iroquois Confederacy. And whereas the confederation of the original 13 colonies into one republic was explicitly modeled upon the Iroquois Confederacy, as were many of the democratic principles which were incorporated into the Constitution itself. And whereas, since the formation of the United States, the Congress has recognized the sovereign status of Indian tribes, and has, through the exercise of powers reserved to the federal government in the Commerce Clause of the Constitution, Article 1, Section 8, Clause 3, dealt with the Indian tribes on a government-to-government basis, and has, through the Treaty Clause, Article 2, Section 2, Clause 2, entered into 370 treaties with Indian tribal nations. And whereas, from the first treaty entered into with an Indian nation, the treaty with the Delaware Indians of September 17, 1778, and thereafter in every Indian treaty until the cessation of treaty making in 1871, the Congress has assumed a trust responsibility and obligation to Indian tribes and their members to, quote, exercise the utmost good faith in dealings with the Indians, end quote, as provided for in the Northwest Ordinance of 1787, First Stat 50. And whereas Congress has consistently reaffirmed these fundamental policies over the past 200 years through legislation specifically designed to honor this special relationship, and whereas the judicial system of the United States has consistently recognized and affirmed this special relationship, now therefore be it resolved by the Senate, the House of Representatives concurring, that the Congress, on the occasion of 200th anniversary of the signing of the United States Constitution, acknowledges the historical debt which this Republic of the United States of America owes to the Iroquois Confederacy and other Indian nations for their demonstration of enlightened democratic principles of government and their example of a free association of independent Indian nations. The Congress also hereby reaffirms the constitutionally recognized government-to-government relationship with Indian tribes, which has historically been the cornerstone of this nation's official Indian policy. The Congress specifically acknowledges and reaffirms the trust, responsibility, and obligation of the United States government to Indian tribes, including Alaska Natives, for their preservation, protection, and enhancement, including the provision of health, education, social, and economic assistance programs as necessary to assist tribes to perform their governmental responsibility, to provide for the social and economic well-being of their members, and to preserve tribal cultural identity and heritage. And the Congress also acknowledges the need to exercise the utmost good faith in upholding its treaties with the various tribes, as the tribes understood them to be, and the duty of a great nation to uphold its legal and moral obligations for the benefit of all of its citizens, so that they and their posterity may also continue to enjoy the rights they have enshrined in the United States Constitution for time immemorial. And further, we take a look to the District of Columbia Act of 1871. And here it states, effective June 1st, 1871, by an act of February 21st, 1871, 16 Stat 419, abolishing the corporations of the City of Washington, D.C., and Georgetown, D.C., and the Levy Court of Washington County, D.C., and replacing them with a municipal corporation known as the District of Columbia. It is also essential and imperative to note that the same year that the District of Columbia was formed in 1871, the United States government no longer formed any more treaties with the Indians and their tribes, because as a municipal corporation, they did not have the capacity to enter into treaties like the Republic, as the Republic was abandoned by the administration at this time. And out of Charlotte's Web, District of Columbia, in response to the poor conditions in the capital, Congress passed the Organic Act of 1871, which revoked the individual charters of the cities of Washington and Georgetown and created a new territorial government for the whole District of Columbia. The act provided for a governor appointed by the president, a legislative assembly with an upper house composed of 11 appointed council members, and a 22-member House of Delegates elected by residents of the district, as well as an appointed Board of Public Works charged with modernizing the city. President Grant appointed Alexander Roby Shepard, an influential member of the Board of Public Works, to the post of governor in 1873. Shepard authorized large-scale municipal projects, which greatly modernized Washington. However, the governor spent 3 times the money that had been budgeted for capital improvements. He ultimately bankrupted the city. In 1874, Congress abolished the district's territorial government and replaced it with a 3-member board of commissioners, appointed by the president, of which one was a representative from the United States Army Corps of Engineers. The 3 commissioners would then elect one of themselves to be president of the commission. An additional act of Congress in 1878 made the 3-member Board of Commissioners the permanent government of the District of Columbia. The act also had the effect of eliminating any remaining local institutions, such as the boards on schools, health, and police. The commissioners would maintain this form of direct rule for nearly a century. It's also important to remember that the post office, which is necessary for all of the administration of government in any country, is directly correlated with the Universal Postal Union. And who sits over the Universal Postal Union? The United Nations. And who presides over the United Nations, especially in criminal matters, because of the motu proprio issued by the Pope? The Vatican. And this is why, as America is Egypt, the copper-colored Hebrews reclassified as Negroes, Blacks, and American Indians, have applicability with the cestui Act and UK legislation right here in America. So I hope that kind of clears things up for people. It gives you a better understanding of how the unclaimed and unsettled lands uh, were really belonging to the Indians, as it was reserved in trust by the British Crown. And even the lands and tenements that were ceded to the United States or held by one of the colonies through the Select Congress Resolution 76, though that is the acknowledgement wherein even the United States and the colonies, even under the present administration via the District of Columbia Act of 1871, still owes those same fiduciary duties for the reservations to the Indian tribes. So whether you go British or whether you go American, either way, a trust is a trust, and it will not fail for lack of a trustee. So I hope this was helpful. If you found value in this content and material, please consider supporting. Any donations can be sent through Cash App to BL2BeFruitful. Any donations over $50 will receive a link to Be Fruitful Training Group's private library as a courtesy. And yeah, everyone do your due diligence. This is not legal advice, financial advice, or tax advice. If you need any of those applicable advices, please seek competent counsel. Again, all praises to the Most High, and we'll see you on the next one. Thank y'all.